Yes, sir. May it please the court, I am Randy Ackley representing Hilda and Bernie Stiller, the appellants in this action. I would respectfully request 5 minutes be reserved for my rebuttal. All of the issues in this case can be boiled down to one unavoidable principle. That principle is that this court and the Florida Supreme Court have been unequivocal in your holding that double recovery on the same element of damages is prohibited. And that's exactly what will happen in this case unless the final judgment below is reversed. If you would take a look at page 3 of...
How do we know that? I mean, it seems to me, and I mean the settlement agreement is long and complex, but it seems to me what we know is that this trust is included in an agreement that involved a negotiated settlement. But how do we know how whatever amount that agreement allocates to this trust goes to your client's mortgage loan as distinguished from some estimate of how that pool is going to perform generally or other deficiencies in whatever set of assets comprises that trust?
That's a great question, and what it boils down to is identifying the parties. For instance, in page 3 of the appendix to the appellant's initial brief, you'll see that the party to this case, or to the case in New York, was the Bank of New York Mellon as trustee for the various pooling and servicing agreements and indenture trustee under various indentures. And then in the first sentence of that petition, petitioner, the Bank of New York Mellon, solely in its capacity as trustee for the 530 residential mortgage securitization trust listed in Exhibit A. Well, if you look at page 90 of that appendix, as you've highlighted, Your Honor, you'll see that this trust that this mortgage is in is part of the 530 trusts that were being petitioned, that were petitioning the New York case. In fact, the final judgment of the New York case cites the Bank of New York Mellon, formerly known as the Bank of, or in this case, the plaintiff is the Bank of New York Mellon, formerly known as the Bank of New York as trustee for the certificate holders, Seawalt Inc. Alternative Loan Trust 2006 6CB, Mortgage Pass-Through Certificates Series 2006 6CB. Every reference within that petition and within the settlement include the trust that's in question here.
I don't think there's any question that this trust is included in the settlement. My question is, your contention is an affirmance here means the bank recovers twice for the same indebtedness.
No, and that's important. We're not saying the bank recovers, we're saying the certificate holders recover. And that's the key here. If you look at the UCC under 678 and 679, a certificate holder basically is an investor. They bought a bond. They bought an investment into the cash flow that arises from the mortgages that have been included in the trust. They're not holders of the notes. They basically invested in the cash flow that the trust as a whole receives. And that's important. The funds that they're investing in are fungible. When they invested in the trust, they weren't holders in due course of the note. The last holder in due course under the UCC
know that the loss that the certificate holders recovered for represent loss attributable in whole or in part to the non-performance of this loan as distinguished from some combination of other loans in that trust or some hypothetical estimate of the performance of that pool of mortgages as a whole.
Two ways. First, because the petition in New York was a petition to settle on all of the damages from the mortgages included in all of the trusts. And I would highlight on page 357 of the appendix where it specifies the damages. And I quote, that the settlement agreement requires Bank of America and or Countrywide to pay $8.5 billion, the settlement payment, into the trusts allocated pursuant to an agreed upon methodology that accounts for past and expected future losses associated with the mortgage loans in each trust. It couldn't be more straightforward. The settlement was to compensate the certificate holders for the failure of the mortgages included in the trusts. And really what the New York case was based on was the fact that the depositor and the trustee, in advertising the trusts, failed to accurately reflect what kind of mortgages would be included in those trusts. So they were compensating the investors for the failure of the mortgages within those trusts.
Yeah, but you don't make the claim that they were paying the investors 100 cents on the dollar.
Absolutely not, but that was their choice. That was their choice. They settled on the reduced amount.
I don't understand. If you agree that they're not getting 100 cents on the dollar, I don't know how you can say they're recovering twice for the same damage. That is to say, unless there is some deficit, or as long as there's some deficit, there ought to be something else they ought to be able to recover.
Not at all, because again, come back to who they are. And the plaintiff in this case is the same plaintiff that was petitioning the court in New York, and it was the certificate holders. And that's key here. The certificate holders are not holders of a note. And again, when a certificate holder purchases a certificate, they're not buying any complete note at all. What they're buying is derivatives that are defined by different elements of cash flow coming out of all of the notes included in the trust, a fungible account. So they've invested in the trust by buying those certificates. Those certificates have no relationship to the individual notes at all. Those certificates are entirely based on the cash flow arising from the trust. So when they settled for all past, current, and future losses related to those mortgages, that's it. That's the whole package of any potential loss that they could have incurred arising out of the default of the loans that are included in each of those 530 trusts. That's the only damages that they had. The only thing that certificate holders are buying is cash flow. They're not buying a note. They're not investing in a secured mortgage. They're investing in the cash flow that each of the trusts would generate. And their investment is based on the representations to them by the trustee and by the depositors when they advertise the trusts in the prospectuses. Prospecti, I'm not sure what the plural is for that. But their whole point is they're investing in bonds, basically, and allowing them to come after the individual mortgagors that are related to the mortgages that are included in those trusts is akin to allowing a stockholder to come against individual debtors to a corporation. It's not appropriate.
So your argument goes beyond just the settlement. You're saying they lack standing.
Yes, but that wasn't argued in
No, I know. I just want to
court.
make sure I understand the extension of your argument.
Yeah, I think that's logical, yes, but unfortunately it wasn't raised in the court below. The thing here is that the Stillers didn't receive any money at all from the certificate holders. They don't owe the certificate holders anything. The last holder in due course, the last arguable party to have any relationship to the Stillers through the note would have been the depositor. So and unsupported. What they've done is they've received damages in New York for any damages that they could have incurred as a result of the failure of the mortgages in the trusts that are included in the settlement, and they agreed to the amount. And again, remember, in Florida courts, compensation for a breach of contract is based on the injuries of the plaintiff. It's not punitive. This isn't about the Stillers and trying to punish them. This is about what are the damages that were incurred directly as a result of any breach by the Stillers to the plaintiffs.
But just to take your argument on its terms, the certificate holders under your argument accepted something less than 100% of what they were entitled to under their terms. So they have an uncompensated loss. Why is it they cannot say that your client And I mean, listen, I'm oversimplifying this because of the commercial relationships involved. But why can't they say that your client is a separate cause or another cause of that loss and recover against them?
Because they agreed in the settlement that this accounts for all past expected future losses associated with the mortgage loans in each trust.
For purposes of their claims against the people who they were suing in New York. I mean, it's not your client's not a party to the settlement agreement.
No. But we're not trying to enforce the settlement agreement. We're using the settlement agreement to highlight the fact that they've already collected their damages for their losses related to this trust.
There's still a mortgage out there that hasn't been satisfied? Is that agreed upon?
That's agreed.
So how do you ever get that removed from the public record? They'll never be able to sell a house with an existing mortgage out there. Do you go modify the settlement agreement in New York to require satisfaction of mortgages be issued?
No, I don't think that the parties in New York, I don't think the plaintiff here is the party to do that with. I think there may be another party out there, but it's not the issue being litigated here. See, the parties here don't have any relationship to this mortgage at all. The certificate holders, again, invested in cash flow. They didn't.
You alleged the mortgage was either void or something like that, unenforceable. You're moving to vacate the final judgment of foreclosure, right?
Right, because the final judgment was void, not the mortgage. The final judgment is void because they'd already received their damages. And this comes back to the Saffer case and to the Montage Group versus...
What were they foreclosing on if it wasn't the
Well,
mortgage?
that's an interesting point. They foreclosed in a state court as certificate holders. I would argue they shouldn't have, but they did. But that, again, is not an issue that's being argued here today. The argument here today is based on the fact that they had already been paid for their damages. No matter what those damages are, they agreed what the damages were and that they represented all past and future losses. The element of damages is the default of the mortgages, and the only benefit that the mortgages provide to the trust is the payments by the borrowers. The plaintiff settled future damages as well as past damages, so it was their choice to settle for $8.5 billion. And they're the ones who agreed to the formula to be applied in allocating that $8.5 billion among the many certificate holders that were included in the settlement.
You're down to 7 minutes.
Thank you, Judge. Another way of looking at the response by the appellees in this case is, well, the Stillers just caught us too late. We got away with it because they had entered into the settlement in 2011 and the Stillers didn't know about it. They've suggested that the Stillers didn't exercise due diligence because they didn't raise this before the final judgment in the case below here in Florida. I'd ask the court to consider that argument a little bit more closely. The certificate holders are both national, domestic, and international. To take the plaintiff's argument, the appellee's argument to its logical conclusion, they're asking the Stillers to have monitored 195 countries' courts, all 50 states' courts, all of the counties in those courts in all of the counties in the United States. It's just untenable and inappropriate. There's conceivable court to see if the plaintiff had settled their damages already in this case. And with that being said, Judge, I would ask that this court reverse the final judgment below, find that it was void or at the very best unenforceable because the damages had already been awarded to the plaintiff in New York.
I'll save you the 5 minutes.
Thank you, Judge.
Morning, may it please the court. Morgan Weinstein on behalf of the appellee. This case involves a situation in which there was a judgment that was entered April 23rd, 2015. Subsequently, the finalization of a settlement in a case in a different state involving different parties in which the Stillers are not a named third-party beneficiary and in which the Stillers do not claim to be an unnamed third-party beneficiary. The Stillers, after almost 10 years of litigation in this matter, have now decided that judgment or that settlement that was entered into subsequent to the judgment in this matter somehow renders the judgment in this matter either void or having no no further prospective application. I think that it's insurmountable, the question of whether it's void. It's not void, and it can't be void, because even if the Stillers are correct about everything that they're saying from a legal perspective, the judgment was entered prior to the settlement being finalized, and a void judgment is one that could have no application at any point in time. For those 4 days, the judgment certainly had application, and there's no argument in response to that. The closest that we get is that judgments can be void for reasons that don't deal with jurisdiction or that don't deal with due process, and this is in the reply brief. However, the cases that are cited by the appellant deal with jurisdiction and due process. We have a case that deals with a bankruptcy stay and the application thereof. That's a jurisdictional question. And we have cases that deal with failure to join indispensable parties. Those are due process questions. There's no question in this case that there was jurisdiction at the time that the judgment was entered and due process, so it can't be void. Regardless, it should continue to have further prospective application for the reasons that are articulated in Section 1B of the appellee's brief. Namely, that the case below does not involve the claims that are at issue in the New York case and does not involve the parties that are at issue in the New York case. And the New York case is exceptionally clear that the settlement is exceptionally clear that it is a settlement between the bony parties, the Bank of New York parties, and the Bank of America and Countrywide defendants. The Stillers are none of those parties. Bank of New York in this case is suing on a mortgage in order to enforce a note and foreclose a mortgage. Those are the allegations in the complaint. We have a note and we have a mortgage. We would like to enforce that note, which contains an optional acceleration clause, and thereafter foreclose that mortgage interest because we have a security interest pursuant to Article 3 of the Uniform Commercial Code rather than pursuing a security pursuant to Article 9. This distinction is important because it's part of what opposing counsel was just discussing when he was talking about chapters 678 and 679 of the Florida statutes. Those would apply to securities, and that is something that a certificate holder may have. However, that's not the plaintiff. The plaintiff is a trustee suing pursuant to chapter 673 of the Florida statutes to enforce a note and thereafter foreclose a mortgage. And that plaintiff is the Bank of New York. And the Bank of New York is operating as trustee, sure, but Bank of New York is still the plaintiff. The certificate holders are not the plaintiffs. And the certificate holders are not even named as part of the plaintiffs. Instead, what we have is Bank of New York as trustee for a particular loan trust, which includes certain rights and obligations of certain certificate holders, but does not include the certificate holders themselves. Instead, Bank of New York Mellon is suing solely on behalf of the trust as trustee, is the named plaintiff, and is suing defendants, the Stillers. This involves none of the parties in the New York litigation, and it doesn't involve any claims in the New York litigation. The claims in the New York litigation all relate to origination, sale, and delivery of certain mortgages, which is why, Judge Solario, when you ask, we don't know how it was traced, we don't know whether this was part of the damages, the methodology that's even discussed by opposing counsel and the appellants, we don't know what that is. We haven't had the methodology discussed. There's been no...
Just to make a simple question out of a complicated case, tell me if I'm on the right track. You get a bunch of mortgages, you bundle them together. Banks sell mortgages all the time. In this case, they sold the return on the mortgages and then misrepresented how much that return was going to be. So they enter into a settlement agreement, pay off the people that bought those returns, which is separate from the mortgage. No one ever bought the mortgages. The bank never gave up ownership of the mortgages, so they retain the right to foreclose for non-payment. Is that anywhere close to what the facts are?
I don't know that that's true because we've had no expert testimony on that question, and there's been no testimony on that question aside from counsel attempting to testify below.
Doesn't foreclose the prospect of bad pun. The settlement agreement doesn't prevent the prospect of later foreclosing on individual mortgages for non-payment.
I agree, Your Honor.
So how does that settlement benefit the appellants in this case?
I don't think that...
Paid money to damages for somebody else. How does that say, oh, you don't have to pay your mortgage anymore?
I don't think that it does benefit the appellants in this case. And what's more, Your Honor, I think that the way that it should be viewed to work is we don't know, it's not even that we don't know whether the losses from this mortgage are associated with the settlement. We don't know that there are losses from this mortgage until we go through with the process of attempting to foreclose the mortgage, and if foreclosure is successful, achieving a result that does not result in a deficiency which the borrowers can then not pay. Because if the bank is made whole through the mortgage foreclosure process, there is no past or expected future loss with relation to this loan. And so the test for whether there is an expected future loss or whether there is a past loss is whether there's a foreclosure that's either attempted and fails or one that can't be attempted in the first place because of some noncompliance by the defendants in the New York case at a prior point in time. In other words, if the Stillers below were able to demonstrate this case should not have gone forward or the plaintiff should not have been able to prevail and proceed to judgment because of some deficiency that was caused by a Bank of America defendant or a Countrywide defendant, and that harmed Bank of New York, then yes, that would have been a past or expected future loss that would have been within the confines of the settlement, likely. That would have been part of the approved and agreed methodology. That's not the case that we have. The case that we have is there's probably not a loss because the Bank of New York was able to proceed to judgment, was able to foreclose on the property, and is now awaiting the result of a sale. And if there's no deficiency, there's no loss. And if there is a deficiency between the amount of the sale and the amount of the judgment, the Bank of New York then has a year to pursue that deficiency in order to eradicate the idea that there would be a loss. So I don't think that the settlement benefits the appellants in this case. I think that the only thing that could happen is that if there was a deficiency by a Bank of America defendant or by a Countrywide defendant prior to the inception of this case that caused Bank of New York to lose this case, it would benefit appellee, application of the settlement. Outside of the confines of this case, in an extrajudicial manner, that settlement would benefit appellee because appellee would have then suffered a past loss or an expected future loss with relation to this loan. We don't have that fact pattern. I want to go to the standard of review for a moment just because I think that there is a dispute there, and I think that it's important that a 9-year-old case which has been on appeal and which has been subject to multiple post-judgment motions is not afforded de novo review when it's on a 1.540B issue, and when the issue involves the question of whether there is in fact a loss. That's a question of fact. And there's been no answer to that question of fact. So application of the standard review is abuse of discretion. Trial court certainly did not abuse its discretion where there was no evidence that this was a loss. And where the only evidence is they were able to foreclose, so there probably was no violation with regard to origination, sale, or delivery. There was no failure to repurchase. There was no failure with regard to Bank of America reacquiring loans from Countrywide. There was no failure with Countrywide with regard to document preparation. There was no failure with regard to servicing, and there was no failure with regard to repurchase of modified loans. And those are the only 5 specified areas in which, if there was a failure, one of the Bank of America defendants or Countrywide defendants would be liable to Bank of New York Mellon. There not being that evidence present in this case, there's no ability to say that there was a loss. There's no ability to say that that loss was associated with any of the conduct of Bank of America or Countrywide, and therefore it's not assumed within the confines of the settlement agreement. If there are no further questions from the court, I believe that I want to raise one further issue, which is Judge Larry, you had talked about not receiving 100 cents on the dollar, and the question of what the bank received from the defendants in the New York case and whether that has a bearing upon this case. I think that not only is it true that because the Bank of New York did not receive 100 cents on the dollar when it entered into that negotiated settlement, that there are other claims out there and there are other measures of damages for which the Stillers should be held accountable, having not paid their mortgage and having still had a mortgage on the property. But also, that's another question of fact, and it's another fact that remains unanswered in this case. I think that there has been a deficiency in post-judgment practice in terms of the facts that were presented to the trial court in order to afford the trial court the discretion to rule in the...
What is the current status with respect to the foreclosures now?
I don't know. I don't know the answer to that question. If the sale has not occurred and is on hold, then once the sale occurs, we'll be able to better measure whether there is a loss to the plaintiff. If the sale has occurred and there is a deficiency, then there's a potential loss to the plaintiff that will be resolved within 1 year of that sale. And if there's no deficiency, then there's no loss.
I'm just trying to figure out what further prospective application the foreclosure judgment has given the current state of affairs under 5405.
Under 540B5, the prospective application would deal, even if there has been a sale, I don't believe that there's been a deficiency decree yet. In other words, there's been a reservation of the right for the plaintiff to seek a deficiency within the confines of that case. That's a process that's quicker and easier than having to file a separate action for a deficiency, and should the plaintiff elect to pursue a deficiency, they would do so in that case. So even if a sale has occurred, I don't know whether it's resulted in a certificate of title, and even if the certificate title's been issued. I don't know whether that's resulted in a writ of possession, and if the writ of possession has been issued, I'm not sure whether we have an issue where there's a deficiency that can still be pursued. So there would be a lot of further prospective application of the judgment in this case in the lower court that would be important for 5.0b5 grounds. And that all deals with issues that would arise that are outside of the confines of the question of any damage to a particular certificate holder, because it's an operation of what the Bank of New York Mellon can do for the trust as a whole. And so to the extent that that's true, and to the extent that the mortgage can be foreclosed, the property sold, the proceeds of that sale going into the trust, and the proceeds of any deficiency also going to the trust for the benefit of all certificate holders to be spread out eventually, that's separate than the question of whether a particular certificate holder purchased a bond, because the trust didn't purchase bonds. The trust exists for the purpose of the Bank of New York as trustee going in and getting these judgments on behalf of the trust to compensate the trust for anything that could be a loss that the Bank of New York as plaintiff could eradicate the loss thereof. With that, I would yield the rest of my time if there are no further questions.
All right, thank you. Mr. Ackley, you have 5 minutes for your rebuttal.
Thank you, Judge. If I may, I'd like to come back to a question that was raised in my initial presentation, and that is, so if they didn't get the complete damages, 100 cents on the dollar, don't they have the right to come back and get the remaining damages from the mortgage in question in this case? Let me make very clear, as that settlement has occurred, there is no recourse for the certificate holders, the plaintiff herein, to the plaintiffs herein, to recover any additional damages from this mortgage. There is no mechanism left for them. They have settled this and they're out of it, and that's the key point here. With regard to who the parties are, again, I would highlight, pursuant to the petition, it's very clear, Bank of New York was acting as trustee for the trust, that is, the 530 trusts, of which the trust in this case was one. The trust in this case is the plaintiff here. They have sued. There is no question. The same parties are before the court.
What was the source of Bank of New York's duty to disclose the New York settlement in the context of this foreclosure litigation? Why was it incumbent upon the bank to make that disclosure?
I think that's a great question, and I don't think it's just this case, though I'm, of course, not representing any other parties in any other cases. But the fact is, if the parties in the New York case were settling their damages and there were cases pending in other courts of the country, they had a right to say, or they had an obligation to inform those courts that they had settled those damages and they were resolved.
What is the source of that obligation is what I'm trying to get at.
I would highlight...
Request or request from the court or something?
No, I would highlight, at least in Florida, the law of Florida pursuant to the Atlantic Coastline versus Safford case, 130 Florida, 598. The Supreme Court in 1938 held, and this court adopted and reasserted in Montage Group versus All Athletech Computer Systems, 889 Southern 2nd 180, that double recovery for the same element of damages is prohibited. And that's exactly what we have here. The element of damages in both cases is the non-payment of mortgages and the potential damages to the certificate holders. It's the exact same element of damages that they settled in New York that they're now trying to take from in this case.
So what happens to the note under your position? What happens to it?
That's
I mean,
a great question, and I would argue that under the Florida UCC chapters 678 and 679, once it's certificated, the mortgage is separated from the note, and a foreclosure is no longer an option, since once the mortgage is separated and not securing the note, it can't be reattached. However, that doesn't mean that you can't enforce the debt. The depositor has the note. The depositor or some other party may very well move to enforce the debt of the note.
Well, the trustee has the note, right? I mean, the trustee came into court with the note?
I don't believe so. Remember the St. Cloud case, Your Honor. In St. Cloud, this court has held clearly that possession doesn't mean you're a holder. And by St. Cloud, I'm referring to 173 Southern 3rd, 1045. Mere possession doesn't mean you have the right to enforce. Mere possession just means you've got the piece of paper. And this comes back to the whole mechanism.
But the note was a negotiable instrument. Isn't it the same as like holding a $10 bill? I mean, if I hold a $10 bill, I get to spend it. If I hold a promissory note, I get to enforce it, whether even under the statute, whether I come by it honestly or
Right, you
not,
don't
so
get the
long as I've
mortgage.
got it in my hot little hand,
I
I can
completely
enforce it.
agree, but there's a difference in the nature of the negotiable instruments. You can't certificate a $10 bill. You can certificate a promissory note. And that's the key issue here. Once they have certificated the note, once they've bundled all of the income from all of the notes in the trust together in this fungible accounts, and then separated out and paid to the different certificates based on the different nature of the income, under 678 and 679, it's no longer a negotiable instrument. Now,
You're going to be out of time in 10 seconds, but I'll give you 30 seconds to wrap up.
thanks very much. But the question's exactly on point. It's no longer a negotiable instrument. It might be able to be repaired and made a negotiable instrument again, but while the certificates are still out there, it can't happen. So here, the damages are the same, the parties are the same. The plaintiff is trying to get away with collecting twice on the same element of damages, and this court and the Florida Supreme Court have been very clear that they can't do it. Thank you very much.
Thank you. Safe journeys.
Thank you.
We'll be in recess.
Are you driving right back, Morgan?
Yeah, well, I'm going to be my couple of friends.
I'm doing the same. Have a safe trip home.
Likewise.
I'm sorry.